Good afternoon. Thank you all for joining us today. I'm Katrina Williams, Director of Planned Giving. I'm excited to welcome you to our Legacy Giving webinar. If you have a question at any point during the presentation, feel free to type it into the Q&A box at the bottom of the screen. Questions will be addressed in the Q&A session at the end. Today, we will explore how you can create a will using an online tool and the importance of having an estate plan. If you decide to take advantage of this opportunity, this service is available at no cost using code SBA ProLife. If you are considering Susan B. Anthony Pro-Life America or Susan B. Anthony Pro-Life America Education Fund or one of its programs as a beneficiary in your will, please be advised that our family of organizations includes both a 501c4 as well as a 501c3. And that 501c language is just tax coding for different charitable or nonprofit organizations, and each has a different role. And together they allow us to carry out our different aspects of our mission. But for your knowledge, I want you to know that a 501c4 bequest is not deductible as a charitable contribution for estate tax purposes. A 501c3 bequest is deductible, and you will receive our estate planning guide after the webinar that provides information and clarity about our organizations. But that is important for you to note as you are considering potential bequests. There's no obligation to leave a bequest to SBA in order to use the service that we talk about today, but of course, we would be so grateful and we would be honored. Our speakers today are Thomas Timmons, founder and CEO of MyCatholicWill.com and MyLegacyWill.com. Tom launched My Catholic Will in 2021 with his brother Dan, creating the first online will writing platform designed specifically to help Catholics plan their estates in accordance with church teaching. In 2024, he launched MyLegacyWill.com, born out of both a growing need and his deep passion for supporting pro-life nonprofits. Partnering with parishes and mission-driven organizations across the country, his platforms have inspired hundreds of millions of dollars in charitable legacy giving. A graduate of Franciscan University of Steubenville, Tom previously served with the Association of Marian Helpers and the Archdiocese of New York. He's passionate about faith, family, and helping people protect and provide for the ones they love most. Dan is Tom's brother, the oldest and wisest of his parents' 10 children. He has been married to his wife, Megan, for 21 years, and together they have 6 children. Dan holds a master's degree from the John Paul II Institute in Washington, D.C. for 15 years before starting My Legacy Will, My Catholic Will with Tom. Dan served in marriage and family ministry for 3 different dioceses in Ohio, including the Diocese of Youngstown, where as Associate Director of the Pro-Life Marriage and Family Office, he assisted a family and dedicated pro-life group in closing and then demolishing the only abortion clinic in the Diocese of Youngstown. That's amazing. Before we hear from Tom and Dan, we have a special guest. I am delighted to introduce the Executive Vice President of Susan B. Anthony Pro-Life America, Emily Midget.
Hi, everybody. Thank you so much for being here and joining us today. We're glad you're here. We really hope that you find this webinar helpful to you as you're thinking through your legacy and estate plans. I know this is something that was on my husband and I's to-do list for a really long time. And it just became really clear to us through losing my father last year, just how important and how much of a gift this is to your family to be able to lay out your wishes and for them to be confident that they're executing your what you desired for your estate. And so my husband and I have been working on this to make sure we leave the same gift to our children. And so we're just thankful for the opportunity to partner with My Legacy Will and My Catholic Will. And we hope that these services really start to help you figure out just where to start. I know sometimes when this is lingering on the to-do list and there's a lot of decisions that have to be made, sometimes you just need that push to know, okay, here's the first question to answer and here's the next step. And so we're really grateful that they're providing a pathway for us to be able to do that. So without further ado, I'll hand it over to Tom and Dan to show us the way.
Thank you so much, Emily, and thank you so much, Patrina. It is an absolute honor for myself and Dan to be here today. And as you heard in the kind introduction, Dan and I are passionately pro-life, and so it is a true honor to be partnered with SBA Pro-Life America and the phenomenal work that you do and protecting the dignity of life. So we're just going to go through a quick presentation here, talking a little bit about our platforms, how they work, and how simple it truly is to create a legacy through those platforms. So we'll start the PowerPoint now, and you should be able to see my screen. This is first and foremost a free benefit to the supporters of SBA Pro-Life America. SBA Pro-Life has subscribed to our platform to provide you with absolutely free service to create a simple online will to protect you and your family. It takes roughly 15 to 20 minutes to complete. And through this next 30 minutes, we'll talk about a few things. So we're going to talk about why this matters and also why some people put it off, what that process actually looks like. Dan will walk us through from your perspective and just really, remove any fear or barriers or just, simply show you how everything works. And then who this would be right for and who it might not be right for. So there are circumstances when you're going to want to speak to an attorney, and we'll talk about a few of those questions. And then, of course, getting into other questions that you bring forward or questions that Patrina has in front of her that she'd like to address. We'd be happy to cover those. And then obviously the importance of leaving a legacy, and in particular, a gift to SBA Pro-Life America, why that's important, and also the fact that it is an option and not a requirement. So one thing that's kind of surprising to a lot of people is the number of people who do not have even a basic will in place. So over 70% of Americans today do not have any will in place. It's possibly shocking, but maybe not, because I know a lot of us are included in that number. So why do we wait? A lot of individuals think that it's expensive. The only way to get a will is to speak with an attorney. That's not always the case. Is it complicated? Do I need, a lot of documentation? Do I need my social security number, bank accounts, things like that? It's not complicated through our process, and it's pretty straightforward, as we'll see in a few minutes here. And then probably the most common reason people don't do it is because they just think, well, now's not the right time. I'll do it later. And this is probably an important point to make, because writing a will is not only important for your family, but it's also something that's really pro-life. It's just as you would want to provide for your family with, suitable work or suitable housing, food. Having a will in place is really important to protect your family, because we all know that it's, God that decides our life and not our own choice. So taking that responsibility rather early on, and even, we encourage people as soon as they graduate college to get a will in place. You can always update it. So what happens when you don't have a will? Well, number one, the state is going to determine who inherits, your property, your assets. If you don't have a guardian named for underage children, again, a judge is going to determine who best to raise your children. This is something frightening, especially for parents of young children like myself and Dan. And that's not something that we want to have happen. Your family's going to carry that weight, especially at a time when they're grieving. So making that time even more difficult for them, and that's not something that anyone wants to burden their family with. And of course, nothing is going to go to the causes that you care about and love and that you support today. So if you are giving to your local church, pro-life organizations, SBA, Pro-Life America, if that's not indicated in your will, none of that will go to those causes that you care deeply about. And again, writing a will isn't really about death. It's about passing on that legacy. It's about what you love in life and giving witness to it in a simple document. And I think that's a lot of the misconceptions that it's only about death. And I kind of flip that on its head, and I like to think that no, it's actually about life. And it's a very beautiful act. So how it all works, Dan's going to walk us through in the next few minutes here and show you exactly how simple it is. So if he'll share his screen, that would be great.
Yeah, so here's a snapshot of the actual landing page for SBA Pro-Life. So this is how you receive a free will. Normally, if you just went to mylegacywill.com or mycatholicwill.com, there would be a $189 charge to do the will. But thanks to our partnership with SBA Pro-Life, this process is entirely free. There's no payment required. So after mylegacywill.com, you're going to want to make sure that you have SBA Pro-Life there, or you can type it in the referral code box, SBA Pro-Life, and that is what will give you the free will. So I'm going to walk you through the actual process. It takes probably about 15 to 20 minutes to get through. It's fairly simple. We don't require any bank account information, social security numbers, things like that. All of your sensitive data, you don't have to put in here. So simple, name, address, email, your birthday, whether you're married, if you have children, if you have pets that you'd like to include in the will. You'll enter your spouse's name, your spouse's birthday, your wedding day, and then you can enter as many children as you have. So I have 3 children here entered, not all 6 of them. So if any of your children are under 18, you'll choose guardians and alternate guardians, and the spouse is defaulted as the primary guardian, and then you can add in alternates below it, and you can add in a number of alternate guardians to take care of your kids if they're under 18, which obviously, as Tom said, is important because that's one aspect we don't want the state to decide. If you have any animals, again, or pets, you can have designate people to take care of your pets, and then also a certain amount of money for pet care on the next page. You will estimate the approximate value of your estate. Now, you don't want to get too hung up on this. This is just an approximation. We have pretty wide ranges here. The whole reason for this is simply so if you do leave a gift to charity, we can pass on the estimated size of the gift to charity. You don't really have to fret about getting this exactly right. And again, you're going to want to include anything that is not previously named that you have beneficiaries named for. So if you have retirement accounts or life insurance policies, things like that, that you have beneficiaries named for, you would not include that in this total. On the next page, you're going to be prompted to consider an optional gift to SBA Pro-Life America. So here is where you can choose the 501c4 or the 501c3 education fund, which is the tax-exempt option. So you can choose either of those. This gift is entirely optional. Obviously, we do encourage you to consider giving a gift, and I'm sure Emily and Patrina and those on the call would be happy with the gift, but it's entirely optional. It's your will, and the will's free whether or not you give. So on the next page, you're going to review that gift. You can search for other charities that are in our platform. You can add in unlisted organizations. So a lot of people add in their local church, their local food bank, things like that. You can always add that in. So here's the 5% gift to SBA Pro-Life America Education Fund. And then the other 95% I will give entirely to my spouse. And then now we're into a contingent section of the will. Some people get confused at this point, but basically this deals with who inherits your estate once both spouses pass away. So that's what this contingent. So that 95% that was just given to my spouse, how does that now get divided? And we have different options, divided between my children, customize that, or we can select give some to charity and then divide the remainder between the kids. So here again, we're prompted to consider a contingent gift to SBA Pro-Life America, which would pass along once both husband and wife both pass away. And again, choosing the 501c3 or the 501c4. And in this case, I'll give 1/4 of that estate, with the other 75% being divided between the 3 children. We can add in cash gifts. So you can give cash gifts to nieces, nephews, friends, relatives, other organizations. You can do that. Real estate, you can designate, if you have, your primary residence or rental properties, designate who gets that. Usually the spouse will be the first default, and then you can choose who gets that alternate gift. And then you can name tangible items one by one. So if you have any collectibles or jewelry or important heirlooms and things like that that you'd like to name one by one, you can name who the primary person is. This would be the first person to receive it upon your passing. If that primary person is not able to receive it, or if they've predeceased you, the alternate person will receive that gift. You'll choose executor, alternate executors to administer your estate. You can name a number of them. And then for funeral arrangements, the only required question is whether or not you've prepaid your arrangements. If you do know your funeral home, place of worship, cemetery, whether you'd like burial or cremation, you can enter all that and that will all populate into the will form. A no contest clause discourages challenges in court. This can be a little confusing, but basically, if you live in a state that abides by no contest rules, if someone who is destined to receive a gift in your estate decides to challenge it in court and they lose the challenge, they will be written out of the will. So some people prefer to include that just to sort of stop the fighting amongst family members, and other people would rather not include that. That's entirely up to you. This is one thing we do recommend that you share your information with any charities that you've included in your will. We never share or sell your data to anybody. So your data, when you use our site, is entirely protected. We're not gonna share that. But it is important for charities that you do give to thank you for that gift, to and stay in contact with you. So we do encourage you to say yes at this step. It's optional, but this does allow us to pass on your name, contact information, and estimated bequest size with any charities you've included. You can type in a personal note here, and then you can conclude it with a salutation of your choice. I've always vote pro-life as my salutation for this will. So your spouse can do an exact mirror will. Sometimes husband and wife like to do different things. That's fine. They can go through and make their own will separately. But sometimes just a click of a button and everything is exactly the same. You have the opportunity to review all of your entries. You don't need to do this step to review, but some people like to look over and make sure they got all the spelling right. You can always go back and make edits at any time. So if you do print out your will, you realize, oh my goodness, I misspelled my niece's name, go back and make an edit, spell it correctly, and then go and print out your correct will. The other thing is you can always make edits at any time. So a year from now, you end up moving states, you have another child, you can go back into this platform and make those edits, print out the new will, and make the new one legal. So we bypass the payment page. It's entirely free, and we're taken to the download page where you can just quickly download your will, your spouse's will, if you chose that mirror will option. And then very quickly, I will go through some highlights of the actual will printout that you will receive. So there's first and foremost a cover page. So this is very important because simply going through this process and getting the will, printing it out, it is not yet your legal will. you need to follow these steps according to your state law in order to make that will legal. Some states require 2 witnesses, some states require 3, some states require 2 witnesses plus a notary. So that's important to look at your state law to see what your state actually requires. And then you're just going to want to make sure that original signed and it will in ink is kept in a very safe place and that your executor knows where to find it. Then you have your last will and testament itself, all those variables that you've entered with all of that legal language. You see the spouse, the children listed here, the executor, and I will skip through a lot of this legalese just to highlight a few things. The guardians here, we are on page 5, who takes care of the kids upon your passing, and then those gifts, the tangible property, that wedding ring, as well as the gift of real estate, and then that gift of pet Fluffy, the orange cat, which will go to family with that $500. And then here on page 7, we get into that residual estate. So that 95 primary percentage to my spouse, and then that 5% primary gift to the SBA Pro-Life America Education Fund, the 501c3. Again, if both husband and wife pass away, this contingent section will kick in, and 75% will be given between the children, with that 25% given to the 501c4 fund as we set up in that will. At the bottom of every page, you're going to want to sign that in front of your witnesses. The witnesses will initial the bottom of every page. And then at the conclusion, we have the witness page, the signature page, which will be signed in the presence of witnesses in front of your witnesses. And then you'll also take that to a notary where your witnesses will join you with the notary and then sign that final page there to make it your legal last will and testament.
Yeah, thank you, Dan. So that's, as you can see, that's quite simple, straightforward, relatively easy, painless process. And we're just going to get into a few questions now, and then jump into others that you may have. So is this going to be right for your situation? From what we've seen, we're going to say that roughly 9 out of every 10 people this is going to work for, right? So it's pretty straightforward. If you have a straightforward estate, if you're, married or single, if you have children, if you don't have children, if you're looking to leave things to spouse, children, family, charity, and if you want guardians named, and if you'd like to update your will anytime on your own. So there are going to be circumstances that would require, or we would strongly recommend that you seek advice of a local trusted attorney. That's going to be situations, for instance, like a child or a dependent with special needs, blended family with complicated wishes. If you own a business, farm, have accounts in, offshore, things like that. If you have or need a trust, if you have a relatively large estate, property in several states, or if you do expect someone to contest it, maybe a child that you've decided to disinherit or something along those lines, obviously it'd be more recommended to seek local counsel. So is this valid in all 50 states? That's a question we get quite a bit, and the answer is yes. So again, as Dan said in the presentation, following your state's guidelines with making it legal, signing that will is important. So following those recommendations as outlined in the cover page is important, but we do have wills made in all 50 states, thousands to date. So you're protected, and this has been reviewed by attorneys all over the country. Can you change it later? Absolutely. So it is important to note, if you do go in and you log in and you make updates to your will at any time, the future will become your legal will. One question we sometimes get is, can I create an addendum to my will that maybe I wrote with an attorney? The answer is no. When you create a will with this platform, the very first line, I believe, that prints out in the will document is that all other wills previously made become null and void. So that is an important thing to note. But of course, that also makes it really easy to update if your circumstances change or move to another state because your will does follow state guidelines. A few other questions. What if you get stuck along the way? Again, if it's uh, a technical question, our team is ready, able, willing to help. Things like you forgot your password, or maybe you just, get stuck on a page. But if it is of a legal nature, we are going to advise you to speak with an attorney. And is this really free, right? So if you're ever asked to pay for the will, don't, right? This is absolutely free. Again, through that unique URL, or through using that referral code. If you find that you see a paywall, you can always type in that referral code. And it's happened on a rare occasion that somebody has gone through, has paid for the will, and then has reached out to our team and said, "Hey, oh, I heard about this from such and such a charity, but I actually paid for it." No problem. We'll get you refunded. No questions asked. So if for some reason that does happen, don't hesitate, reach out. But this is absolutely free. So finally, before turning it over, again, just want to make an important point about the invitation to give back. This is something that's really important. This is actually why Dan and I created this platform, because we see the significance of what this means for incredible nonprofits like SBA Pro-Life America and what your gift can do. Number one, always think of family first, right? They're your first priority. But a gift in your will costs nothing today. It's simply entering something like a small percentage, 5 or 10%, can be a significant amount for the future once your estate is liquidated and the executor takes care of your affairs. And of course, it's never locked in, right? You can go back, you can make changes, and we see this happen all the time where individuals will give, a lot of times a smaller gift and increase down the road. And so it's completely in your control in terms of what you're giving back and who you're giving back to. And it's also more ordinary than you might think. Right now, I believe over 40% of individuals coming through our platform are giving a gift back to charitable causes they support, which is incredible. 5% is just about the median, but 1 in 3 are giving 10% to those organizations they support. And these amounts do add up. So just for context, roughly 60 million has been committed to the nonprofits we work with and partner with in just the last year alone. So, obviously, regardless of your estate size, again, completely optional, but encouraged to giving back to those causes that you care deeply about. Next, and almost wrapped up here, I'm going to make a request that anyone watching this webinar, I would strongly encourage you, if you have a few minutes, just to start your account right after it ends. You don't have to finish it. We'll send you friendly reminders to get it wrapped up. But I would encourage you to either go to mycatholicwill.com, SBA Pro-Life, or mylegacywill.com, SBA Pro-Life, and simply start that account so that you can take those next steps and have a legal will in place in no time at all. And we're going to get into your questions now. There are some listed here, which we may get into, but I'll turn it over to Petrina if she has anything in particular that would like to be addressed. And of course, thank you so much for your time today. It's a real privilege and honor to walk you through this platform. Thank you.
I had to unmute myself. I'm sorry about that. Thank you so much, Tom and Dan. As I'm looking over the questions, you have answered anything that's come in. I would like to address something though. When Dan mentioned life insurance policies, retirement accounts, and those types of assets, if anyone is, thinking, can I name a charity as a beneficiary of a retirement account or other financial asset in a will, the answer is no. Though anything that requires a beneficiary designation form, that runs outside of probate. And so whatever you have listed, what person or charity organization that you have listed on that beneficiary designation form, regardless if you decide, hey, I'm going to make a change in my will, that will not work. Whatever is listed as the beneficiary as on that beneficiary designation form, that is the beneficiary. So those different assets were brought up here. And so in case anybody's wondering, I'll just throw that in my will, or I'll make a change about those in my will, that will not work. You'll need to create or request a new beneficiary designation form and then identify whoever or what organization you would like to become the new beneficiary on that designation form. I did want to just a point of clarification there. But in terms of questions, you've answered everything that came in. I feel like, is there anything that you would like to address that hasn't been brought up or mentioned? Any last minutes?
Dan, do you have anything on your end that we often hear?
Yeah, that was pretty thorough. It's for US based clients, US based individuals only. So sometimes we do get requests. I got a request today from someone in Canada, and that's pretty common. Our attorneys did not review Canadian law, so we can't guarantee, anything in Canada will be legal.
Right. Yeah, that's important to note.
Okay. Well, thank you. So much. It's important because I'm going to have some folks that are not here. Actually, I've gotten some messages from folks that are out of the country. So thank you for mentioning that. Before I close, I do want to mention also that I received several questions about trusts before this webinar. And so that is a topic that we will cover in our next webinar. Everyone's estate and personal circumstances are unique, and your estate encompasses everything you own, and your planning needs will depend on your individual situation and goals. And our goal is to provide a variety of tools and resources and information to help you navigate the estate planning process. And that's why we cover a range of topics and options so you can find the resources that are most helpful to you. So that brings us to the end of our webinar. Thank you to our speakers and to everyone who participated. You will receive a link to the recording of today's presentation and a copy of our estate planning guide. If any questions arise, please connect with me. My email is on the screen. We're so glad that you could join us, and we hope you'll stay connected. We look forward to seeing you again for the next Plan Giving webinar in October. Take care.